Good evening, my lady. My name is Mr. Pelosi, and I appear as junior counsel for the appellants. Alongside me, appearing as senior counsel, is Mr. Taylor. Appearing as junior counsel for the respondents is Mr. Robinson. Apologies. Appearing as senior counsel is Miss Anderson. Before I proceed with my submission, would your ladyship like a brief summary of the moot problem?
No, I've had an opportunity already to have a read of the Sheriff's decision in this case, which I understand in the lower court, Sheriff McCarroll decided that the extradition would proceed. Is that correct?
That's correct. If it pleases your ladyship, may I proceed with my first submission?
Indeed.
By way of signpost, my lady, I will deal with the first 2 points of appeal, and my learned senior shall deal with the last 2. My submission begins with the absence, or how there's an absence of prosecution decision on behalf of the Spanish authorities as they bar Mr. Van Dijk being extradited, especially since there is an ongoing investigation in the UK. I will then go on to say that the burden is on the Spanish authorities to prove the contrary, whereby they need to show that Mr. Van Dijk's absence is the sole reason for the lack of decision. Lastly, I will submit that a mutual legal assistance request is what Spain should use to investigate Mr. Van Dijk, as opposed to a European arrest warrant. My first submission is with regards to the Extradition Act 2003, and in particular Section 11, subsection 1AA, and how the absence of Mr. Van Dijk's bars the arrest warrant, as it does not affect whether the Spanish authorities wish to charge and try him. You can find this at page 28 and 29 of the Act, or tab 1 of our bundle.
Is that the blue folder?
Yes, that is the blue bundle.
Sorry, can you repeat the citation 28 and 29? Was
Page
that?
28 and 29, or tab 1A.
Thank you, yes.
Would your ladyship like me to read the relevant provision?
Can you simply direct me to it, please?
It's section 11. It states bars to extradition.
I'm obliged. You've already highlighted the relevant part. Would that be correct?
Yes, that's correct, my lady. My lady, from the outset, it can be deduced that Spain are in no better position than the UK currently are, both with ongoing investigations. Ongoing investigations that have not yet concluded in a decision to prosecute. However, from the current investigations in the UK, Council would submit that the UK have a good case to investigate, given their findings. The wording of the arrest warrant is also a speculative proposition in the sense that it suggests that the interview is very much needed for the prosecution to commence. It is important to note that Spain merely want Mr. Van Dijk in connection with. He is not suspected of the crime. However, the fact that the Spanish authorities wish to extradite him seems rather disproportionate. My lady, there are alternatives in which the Spanish authorities could investigate Mr. Van Dijk alongside the UK with the use of the mutual legal assistance request. However, they have clearly chosen not to use it. The use of this allows the member state to investigate without extradition. However, I will elaborate on this further in my third submission. The fact there are alternatives, however, which Spain have not pursued, points towards there is a need for more evidence before they can commit to a prosecution decision. This is shown further by the fact that our learned opposition seek not to prosecute in absentia. In other words, Mr. Van Dijk not being there. My lady, my second submission is with regards to Section 12, capital A, of the Extradition Act 2003, and how the law puts the burden on the Spanish authorities to prove that a decision has been made or that Mr. Van Dijk's absence is the burdening factor to a prosecution. You can find this section at the end of page 31 leading on to 32, or tab 1 of our bundle.
Yes, thank you for that.
Section 12A1 is split into two parts. To paraphrase in context, Part A states that the extradition is barred by reason of absence of a decision to prosecute if and only if 1. There has been no decision made as to a prosecution, and 2. Mr. Van Dijk's absence is not the sole reason for the lack of decision. Part B states...
I take it what you would say here is that on the information that you've been given, we don't have that criteria is not met.
That's correct, my lady. And therefore we have to proceed to the second part of the test, which is subsection 1B. I'll continue. And those representing Spain need to prove that, 1, they have made a decision to try and charge Mr. Van Dijk, or 2, where a decision has not been made, Mr. Van Dijk's absence is the sole reason for the lack of decision. My lady, relating it to the facts at hand, it is clear from the European arrest warrant that the issue with the Spanish authorities is that they need more information to proceed with their investigations, not Mr. Van Dijk's presence. As a result, the burden is on the Spanish authorities to prove the contrary, that Mr. Van Dijk's presence for questioning is the sole reason why a prosecution cannot be brought. As there is only a view to prosecution, speculative propositions aside, the investigation is at an early stage, and thus counsel would submit that Mr. Van Dijk need not be extradited whatsoever.
Is the factor that he's also would go as far as perhaps to say even a possible suspect in something in the UK, does that have any relevance to the question that's before the court today?
My lady, the reason that there is an ongoing investigation in the UK, counsel are not conceding that one prevails. We are merely saying that they go side by side in which both authorities can investigate Mr. Van Dijk at the same time, whereby in the UK we'll go through the normal process. However, in Spain, they can send a mutual legal assistance request to the UK authorities, whereby the UK authorities are then obliged to interview Mr. Van Dijk, a list of questions that were given to them by Spain, and then the information is then given back to Spain. Purely on the facts here, extradition does seem a bit disproportionate, or counsel would submit that it seems a bit disproportionate, given that there are other less intrusive methods.
And can I ask if you can explain to the court what those less intrusive methods might be?
The less intrusive methods is the mutual legal recognition request.
And what would that practically be?
Practically, that would be Spain sending questions to the UK authorities, the UK authorities then interviewing Mr. Van Dijk on their behalf, the questions that they so wish, and that information then being feeding back to the Spanish authorities.
Thank you.
My lady, my third submission is with regards to the mutual legal assistance request, which I will contextualise through the case of Spanish judicial authority against Arranz, reported in 2015 at the England and Wales High Court, case number 2305. Apologies, my lady, counsel were unable to get holding of the law report. However, we submit the neutral citation as an alternative.
Noted.
Would your ladyship like a brief summary of the facts?
Yes, please. Do I have a copy of it here in the...
Yes, it is at paragraph 56 of the judgment, or tab 2A.
Yes, if you could give me a précis of the background to the case, that would be helpful before we get to paragraph 56.
A request from Spain to the UK for the extradition of a person to face terrorism offences was barred using section 12A, which I reference in my second submission, as a decision to prosecute had not yet been taken by the Spanish authorities. The person in question had produced alternative means, namely a mutual legal assistance request, whereby Spain could investigate a case without the need for an extradition order. The Spanish authorities failed to produce evidence to the contrary, and as a result, the extradition was barred. I seek to rely upon the opinion of Lord Thomas at page 56, or tab 2A.
Page 56, or?
Paragraph 56, my lady.
Thank you.
He states, where evidence is adduced which shows that a means of examination of a defendant is possible, either through the use of mutual legal assistance convention or otherwise before the decision to prosecute is made, then it is for the requesting European judicial authority to prove by adducing evidence to the requisite standard of proof that the test in section 12, capital A, subsection 1b2 has been met. My lady, carrying on from my previous submission, the Spanish authorities have an alternative means to investigate Mr. Van Dijk without the extreme need for his extradition. This can be brought in the form of a mutual legal assistance request, which enables the Spanish authorities to submit, as I said, a list of questions. There are other alternatives, however, we would probably propose that Council would do such in order to obtain information. My lady, I realise I've run out of time. May I conclude my submission?
Indeed, proceed.
Thank you. Spain have not done this whereby they could gain more information on Mr. Van Dijk to aid their investigations through a much less intrusive but more reliable method. It is more information they need, and this can be obtained without Mr. Van Dijk being in their captivity. My lady, to conclude my submissions, the speculative nature of the European arrest warrant points towards Spain's reliance on Mr. Van Dijk being in the country to proceed with their investigation, completely ignoring the less intrusive method through mutual legal assistance requests, as well as the ongoing investigation in the United Kingdom. If Spain followed the MLA request, then they may have a case to charge Mr. Van Dijk in absentia. However, the fact they did not proceed with this warrant to gain evidence points towards Spain using tortuous methods, which has been mentioned in the reportings of the moot problem, to gain such information. My lady, that concludes my submission if there are no further questions.
Would it be fair to say that what your position is that in the first instance, Spain should ask through mutual recognition for the UK authorities to interview, and then if they had enough information, his position may solidify abroad, and then if he was in a position where he was an actual suspect or was charged with an offence, that would bolster a later, more proper application, but the application presently is premature. Would that be correct?
That is correct, my lady.
I'm obliged.
Thank you.
Robinson for the respondent, my lady. My lady, my submission has quite a lot to it, so if I may just begin.
Indeed.
Thank you. My lady, the respondents submit that possible charges pending is the same as there being no charges present and no charges brought, and as such, the warrant for extradition should be given effect. For Spain to prosecute in absentia, as my learned counsel suggested, would be inherently unfair. If I could, at this early stage, bring your ladyship's attention to the respondent's bundle, the black folder. Divider 6, tab A, where she will find the Extradition Act 2003, section 22.
Yes, I'm obliged.
Thank you. My lady, this section applies to those who have been charged with an offence in the UK. This, it is submitted, does not apply to Mr. Van Dijk, as no charge has been brought. Had there been a charge brought, the judgment, according to subsection 2, the judge must adjourn the extradition hearing until the charge is disposed of, withdrawn, discontinued, or the date is deserted pro loci tempore. It is submitted on this ground that without any actual charges being brought, there is no reason and no obstacle under this ground to prevent the extradition order having any effect.
So, can I just clarify, although, because he has not been charged with an offence in the UK, your proposition is that that is not something which would then hold him here. Therefore, the Spanish authorities are in a better position because he has not been charged with an offence. Section 22 isn't a bar.
The Section 22 is no bar because there have been no charges brought. That's correct.
I understand.
Thank you. If I may move to the second point of appeal.
Yes.
Thank you. My lady, the respondents submit in answer to the second ground of appeal that the purpose of the warrant is a legitimate one, since it falls within the scope of the Extradition Act, and that the warrant should not be set aside. I apologise in advance for jumping your ladyship back and forth with the authorities.
That's okay.
If I may start by directing your ladyship's attention to the Council Framework Decision under Divider 3. This is the Council Framework Decision 2002 on the European Arrest Warrant and surrender procedures between Member States. I cite particularly from tab B in this instance, under General Principles, Article 1. My apologies, it said Divider 3 and tab B.
3. Thank you, I have that.
Thank you. If I may read?
Yes.
The definition of the European arrest warrant and obligation to execute it. Subsection 1 reads, the European arrest warrant is a judicial decision issued by a member state with a view to arrest and surrender by another member state of a requested person for the purposes of conducting criminal prosecution or executing a custodial sentence or detention order.
Now, may I stop you there and ask whether or not what has been sought in the arrest warrant in this case squares up with the section that you've just read?
I will come to that later in my
I'm
submission.
obliged to have taken you out of order.
Not at all, not at all. Subsection 2 reads, Member States shall execute any European arrest warrant on the basis of the principle of mutual recognition and in accordance with the provisions of the Framework Decision. My lady, the principle of mutual recognition prevents Member States from reviewing the substantive merits of another state's judicial decision. As such, providing the warrant falls within the scope of the Extradition Act, it's legitimate and should be given effect. If I may direct your ladyship back to Divider 6, the Extradition Act, at tab C this time, section 64, under interpretation. My apologies, Divider 6, my lady.
6.
Tab C.
Yes, I have that.
Thank you. Subsection 1. This section sets out whether a person's conduct constitutes an extradition offence for the purposes of this part in a case where the person, A, is accused in a Category 1 territory, Spain in this instance, of an offence constituted by his conduct. Again, I apologise for moving you back and forth, but moving back to Divider 3 and tab D of the framework, which is Annex 1 of the framework. My apologies. Divider 3, tab D.
Yes, I have that.
Annex 1 is a skeleton, if you will, an example of how a warrant would be worded.
Yes, I see that.
This warrant reads, this warrant has been issued by a competent judicial authority. I request that the person mentioned below be arrested and surrendered for the purposes of conducting a criminal prosecution or executing a custodial sentence or detention order. To compare this with the wording in the case at hand,
Yes.
per the facts, the public prosecutor of Madrid, this would be the competent judicial authority in this case, wishes to interview Dirk, the person mentioned below, presumably his... my apologies. Presumably his full name would be cited later on. We appear to already have the correct person. In connection with explosive and bomb-making materials found in Madrid with a view to bringing prosecution.
Now, may I take you back to then tab 3?
Yes, Article 1.
Tab 3, Article 1. What interests me here and what you've touched upon is that the European arrest warrant says that a requested person for the purposes of conducting a criminal prosecution or executing a custodial sentence or detention order. Now, in contrast, what we have with Mr Van Dyke is not conducting a criminal prosecution, is it?
On the face of it, to read the words that way, perhaps not. If I may bring your ladyship's attention to Divider 1, Tab G, the case of Halali. Halali and the Central Court of Criminal Proceedings number 5 of the National Court of Madrid.
Okay, that's 1G.
Yes, 1G, my lady. It would be paragraph 26, print page 6. This is one of several points of appeal in this case. That was in this case the point of appeal in question was that the word accused had not been used in the warrant, and the question that the court decided was, what message does the warrant give to the appellant or any other reader?
So I see the question that was posed by the court was the appellant accused of any offence? Is that correct? And can you direct me to the section that has the dicta which explains what that is? I think it might be over the page. Would that be correct?
I don't have sight for the moment. May I consult with my co-counsel, who will hopefully find it for me.
Please do continue.
Thank you. If I may just compare the two texts while we find the wording there. For the purposes of conducting a criminal prosecution, to conduct requires investigation and surety. It may be an earlier stage, but it would seem that there's enough evidence that Spain have deemed it appropriate to issue the European arrest warrant with a view to bring a prosecution. It might be an early stage that he is accused under, but under the ordinary reading, it's arguable that he is the accused. I believe that the section your ladyship was asking for... No, it's not. Apologies, we don't have it yet, my lady.
I think I may have heard you mention it just as you were...
I believe it's the top of page 7, reading, I request to arrest and deliver the judicial authorities the following person.
Okay, thank you.
So if I may jump your ladyship back to divider 6 and tab C, back to section 64, subsection 2 this time.
Yes.
Divider 6. If I may, the conduct constitutes an extradition offence in relation to a Category 1 territory if the conditions in subsections 2, 3, or 5 are, 3, 4, or 5 are satisfied. So to reapply the test in Halali, in connection with explosives and bomb-making materials found in Madrid, if it were required to be arguable under subsection 3, would fall within the extradition offence of terrorism, if it was required to, or under subsection 4, would fall comfortably within the criminal procedures in the United Kingdom.
I see. I understand.
Thank you. Subsections 3 and 4 both read very similarly. The conditions are that A, the conduct occurs in the Category 1 territory. That would be Spain in both cases. Part B, the conduct will constitute an offence under the law of the relevant part of the United Kingdom if it occurred in that part of the United Kingdom. I will come on to clarify that in a moment. And 3C, the conduct is punishable under the law of Category 1 territory. Or 4C, that the crime would be punishable under the United Kingdom's law for a minimum time. To clarify that this would be an offence in the United Kingdom, I have divided to tab E, the Explosive Substances Act, 1883, section 3.
I think I won't look at that. I think I will
In
take
the
it
interest
that
of
I would
time,
know in judicial knowledge that would be an offence.
Thank you very much. 20 years would be the punishment.
Well, that wasn't within judicial knowledge. I'm obliged for the information.
Finally, council framework decision. Should your ladyship have any, or should the court have any concerns about sending Mr. Van Dyke, and should the prosecution be discontinued or abandoned him not being able to return. If the domestic courts did find a wish to prosecute him, it is submitted that under Divider 3, Tab F, the Council Framework Decision, Article 24 regards postponed or conditional surrender.
What tab is that, sorry?
It is Tab F under Divider
Tab
3.
F,
I'm
thank you.
aware I've run out of time. This is my last point before I conclude, if that would be.
Please do continue.
Thank you. Article 24, subsection 2 reads, instead of postponing the surrender, the executing judicial authority may temporarily surrender the requested person to the issuing member state under conditions to be determined by mutual agreement between the executing and the issuing judicial authorities. The agreement shall be made in writing, and the conditions shall be binding on all authorities in the issuing member state. That is to say that should the prosecution be abandoned, we wouldn't lose Mr. Van Dijk should there be a domestic prosecution.
So the proposition that you're forwarding is, if in the circumstances Spain does not proceed, then the UK would, under this section, still be allowed the authority to retain him and consider prosecution of him in their jurisdiction. Thank you.
If I may briefly conclude.
Yes, indeed.
Thank you. In conclusion, my lady, we ask that your ladyship dismisses this appeal and allows the extradition, since there have been no domestic charges brought against the appellant, and further, that the European arrest warrant falls within the jurisdiction of the Extradition Act 2003, and as such should be given effect. Thank you.
Thank you.
Good evening, my lady. As previously stated, I am Mr. Taylor, and today I appear as senior counsel for the appellant in this matter, Mr. Van Dijk. As senior counsel, I will tackle the third and fourth points of appeal concerning the human rights considerations of private and family life and the prohibition of torture and inhumane or degrading treatment. These are Articles 3 and Articles 8 of the European Convention on Human Rights, respectively. I will make 4 submissions to the court today. Firstly, a concession that under these circumstances, and taking from the relevant case law, the Article 8 considerations are not relevant in this matter. This is a serious crime. Terrorism by no means can be compared to the lesser crimes in the very few cases where Article 8 considerations have been considered to override the public interest in extradition. Secondly, that the presumption of absolute compliance of contracting states with convention rights may be rebutted where there is evidence to the contrary. Thirdly, that Spanish cases taken to the Court of Human Rights have resulted in rulings of breaches of Article 3 due to a lack of investigation of complaints by Spanish courts. This would be investigation into matters of torture and inhuman or degrading treatment.
And do you have authority that you'll take me to for that?
I do indeed have authority, yes. I will clarify that authority at the time, my lady. Finally, that the Council of Europe's review of Spain's practices concerning Article 3 illustrates a system to which, if Britain extradited Mr. Van Dijk, there would be a real risk of his being tortured. If any risk of a breach of Article 3 is to be found by your ladyship today, the extradition may not occur. As such, the appellants will urge your ladyship to allow this appeal. Firstly, my lady, if I may direct your attention to the blue bundle and the case of Tarakel against Switzerland. This is under Divider 3 of our bundle. It's quite a way through due to the large Extradition Act. This is application number 29,217, made in 2012, and the case was heard by the Grand Chamber in November 2014. Now, this case does not concern extradition. It concerns matters of asylum and the regulations known as the Dublin Regulations. Now, this is an asylum system under which peoples are meant to register for asylum in the first state of the EU in which they arrive. It is submitted that there can be parity drawn between this EU legislation and the matters on the European arrest warrant, as the intention of both legislations is to encourage mutual work between contracting states in order to tackle problems. In the case of the European arrest warrant for a crime, and in the case of the Dublin regulations for asylum. Each is underpinned by principles of fundamental rights, and it is conceded that a presumption must exist for effective usage of these regulations that states under the ECHR will comply with their obligations. This does not, however, mean that this cannot be rebutted. If I may direct my lady to tab 3A of our bundle, this is the orange tab, it is stated that where there are systematic flaws in the system,
Sorry, can I stop you? Can you just tell me where it's stated, what paragraph?
I don't know the paragraph, my lady. It's highlighted. It should just be over that page.
Right. I've got the highlighted part.
It does go over the page, unfortunately.
Yeah. No, that's fine.
My lady, this is stated that where there are systematic flaws in the system, where a person is being removed to, which contradict Article 3 of the Convention, the presumption of compliance can be rebutted with adequate evidence. This will be submitted later with Spanish cases of the Court of Human Rights and a report of the the Council of Europe's High Commissioner. Now, at tab 3B, the standard of proof required is given. This standard is that if there is a real risk of any breach of Article 3 occurring, so we are not looking for a standard of beyond reasonable doubt that torture absolutely will occur. What we are looking for is that if there is any real risk of torture or inhuman or degrading treatment occurring, then extradition cannot occur.
Can I ask what you might consider the difference between simply a risk and a real risk is?
Well, a risk, my lady, must be considered as just any general consideration of the court in an extradition matter that things may occur in a state. There may be some small deficiencies in the state system, or their prisons may not be up to quite the same standard as one might expect. A real risk would be one which is supported and backed by adequate evidence. And it is submitted by the appellants today that there is indeed adequate evidence, and a real risk, therefore, will occur. If I may now direct my lady to the case of Esteberia Caballero against Spain. This is application 74016. The application was made in 2012. Now, before proceeding with my submission, I wish to clarify that your ladyship has been made aware of the situation of this case and the translation which has occurred. The original French is provided under Divider 4, and the translation is provided under Divider 5. Only facts of alleged torture will be used, and there is no necessary interpretation of conceptual terms which may be lost in translation.
I see. So what you're explaining to me is that it's not an official translation, and
it is not, no.
And from what you wish to take from this, although it's not an official translation, there shouldn't be anything, hopefully, that arises that is an argument in relation to legal terminology.
No, there has been no translation of. If there had been, for example, translation of terms such as negligence, that may involve some things which could be lost in translation, sides to the word, meanings of the word which exist in English but not in French. Here it is submitted that this is simply very basic facts of alleged torture, and as such there will not be any translation loss.
Okay, well, you'll proceed on that. I'll proceed on that basis. I'm obliged for you bringing it to the court's attention.
Thank you, my lady. Now, this case concerned a suspected member of ETA, the infamous Basque separatist group responsible for the Madrid bombings in 2005. The lady in question was arrested on suspicion of involvement of terrorist activity and association with a known terrorist organisation, that being ETA. Her allegations included, as is summarised at tab 5B, that she was subjected to suffocation sessions using a plastic bag, so the placing of a plastic bag over the head to asphyxiate her, blows to the head, shouting in the ears, strikes and shocks, sexual humiliation, including the legs of the stool in her cell being inserted into her, the drawing of hair during her arrest when she was dragged from her bed and not allowed to be clothed, and also threats against her family, who she was not able to contact due to the fact that she was in incommunicado detention. As all of this occurred in an incommunicado setting, whereby she was separated from any human contact, other than those allegedly torturing her, the court-appointed lawyer, and, when her appeals for a doctor were granted, a court-appointed physician, there is a particular risk that she would be subjected to treatment which would be contrary to Article 3. There's also a risk, which later came to be in the case, the failing of the Article 3 claim on a substantive basis, that the investigation into these issues would not be in-depth enough for the Article 3 claim to be granted. Now,
I hesitate to interrupt. I see in this particular case, obviously, what is being alleged, if that was to be substantiated, would be clearly a violation of Article 3. What do we have, or what do I have before me in this case to suggest that this accused person, if he was returned to Spain, would suffer these possibilities?
Absolutely right. In the case at hand, the allegations under which he is being extradited are ones which, in Spain, under the Spanish criminal code, would constitute him as a terrorist. And now, I believe that my learned friends have cited a case with evidence to suggest that incommunicado detention does not occur, this being the case of Hilali. Incommunicado detention does not occur, and that torture and things such as this do not occur. The case of Hilali is from 2006. The case in front of my lady currently is from 2011. There are other allegations of this which I'll bring to light in the report of the Council of Europe's High Commissioner, and it cannot be said that there is no issue of this in Spain. There is clear evidence that Spain has a history of doing such things, and I will later submit that this is in fact systematic, and that as such a real risk is present and extradition cannot occur. Now, at tab 5C, it is stated that the failure to find an Article 3 substantive breach was due to the procedural failings of the Spanish judiciary in refusing to review serious and well-founded claims of torture or ill-treatment. Now, as an Article 3 substantive breach was not found, this may dissuade the court from ruling that there is a real risk. However, it is submitted that it is a very troubling state of affairs that the Spanish judiciary have refused requests to investigate such matters, and as such, the prosecuting authority cannot be certain that such matters won't occur in this case. It is submitted that this constitutes a real risk, and as such, extradition cannot occur.
Thank you.
Finally, if I may direct my lady's attention to the report of the Council of Europe's High Commissioner. This is Niels Muiznieks, and it's his report of his visit to Spain. Now, just to clarify, the role of the High Commissioner is to visit contracting states of the Council of Europe and ensure that they are upholding their obligations under the European Convention of Human Rights. He goes essentially on circuit visiting multiple countries and will visit specific countries if claims are levied which require his attention. Now, in this matter, this considers his visit to Spain in 2013, and if I may direct my lady's attention to tab 6A of our bundle.
Yes, thank you.
Now, this states that ill treatment and impunity of state offenders are a long-standing issue in Spain, particularly in matters of incommunicado detention. So it is submitted to the court that this is a clear allegation from the High Commissioner, who is at the very least incredibly persuasive as the Council of Europe's most trusted advisor on these matters, that there is systematic issues with how Spain treats its suspects of terror. Secondly, if I may direct my lady's attention to tab 6B.
Yes.
This states that, by its very nature, detention incommunicado, that is, without contact to the outside world, which it is submitted as a terror suspect Mr. Van Dijk would be subjected to, by its very nature leads to human rights violations, particularly those of Article 3. Finally, I wish to bring my lady's attention to a matter which must be of great concern, and this very much drives home the submission that systematic failings are present in the Spanish system. This is the practice of granting pardons to those in the police force and in the Guardia Civil, which is the armed police who are tasked with tackling issues of terrorism, granting pardons to those who have been found guilty of torture in the Spanish courts.
Are we not straying somewhat, though, from the real nub of what you have to persuade me, which is that that there will be a real risk, not that other people are acquitted for offences against people, but rather that there is a possibility, a real risk of torture?
My lady, if I may answer that by saying that the intention of this submission is to show that under Tarakel, all that must be substantiated is a real risk that this may occur. And this requires a systematic failing. The evidence presented at tab 6C showing the practice of granting pardons suggests that Spain is not against entirely the practice of using torture to tackle terrorist issues. Spain has had many internal terrorist issues, particularly with the ETA and the Madrid bombings and things such as this. And this practice of pardoning people gives to law enforcement officials the idea that they may very well take part in torture and deliver inhuman or degrading treatment to terror prisoners, and will then be pardoned or receive lesser sentences. It is submitted that this, at its very core, shows a systematic failing and a systematic refusal of the Spanish judiciary to tackle matters of torture, inhuman and degrading treatment. As this is the case, the matter of Tarakel, read as would be with the European arrest warrant instead of asylum procedures, is satisfied. There are systematic failings which will lead to a real risk of torture occurring if Mr. Van Dijk is extradited to Spain. As such, extradition cannot be ordered. Thank you, my lady.
Further questions?
Good evening, my lady. My name is Miss Anderson, and I appear as Senior Counsel for the respondent. My submissions shall deal with points 3 and 4 of the appeal. My first submission, that in the circumstances of this case, do fulfil the criteria for a justified infringement of the appellant's Article 8 rights. And my second submission, that the principle of mutual trust between the UK and Spain operates to provide assurance that each member state shall apply the same standards in application of the Convention.
Thank you.
If your ladyship has no questions, may I move on to my first submission?
Yes, certainly.
With reference to case law, the test applied for the interference with the Article 8 right with respect to extradition orders proves that the circumstances in this case would render an interference with the appellant's rights proportionate and justified. Article 8 protects the individual's rights to maintenance of relationships with others and a settled and secured place in the community. However, Article 8 is a qualified right, meaning that under subsection 2 of Article 8, these rights can be interfered with so long as they are in accordance with the law and are necessary in a democratic society. In this case, the appellant's rights should be interfered with for the prevention of disorder and crime. May I now refer your ladyship to divider 5 of the bundle? That is the black bundle.
Thank you.
This references the 2010 case of Norris and the Government of the United States of America, which is case 9 of the UK Supreme Court records. In this case, Mr. Norris was found guilty of price fixing and was due to be extradited to the US to be prosecuted. On appeal, he argued his Article 8 rights would be disproportionately breached if extradited, taking account of his poor health, his wife's worsening depression, and their increasing mutual dependence on each other. However, it was held that the consequences of disruption of this extradition were inevitable, and the circumstances in this case were not distinguishable from most other extradition cases. Thus, there were no truly exceptional conditions of this case which convinced the court, and as such, the appeal was unanimously dismissed.
Now, can I ask, you're proceeding on a basis that the Article 8 right can be interfered with because of the nature of the allegations that are being made in Spain, is that correct?
I am submitting that an Article 8 right can be interfered with where the public's pressing social need takes trumps.
Indeed, and that's what the section tells us. But bringing it to the circumstances of this case, I understand your argument clearly. You're suggesting that in this case, the Article 8 rights that he has in this country are entitled to be interfered with because the Spanish authorities, what? What is it that the Spanish authorities are saying that entitles the Article 8 rights here to be interfered with?
They would like to question the appellant and therefore they would like to question the appellant after he has been accused of being in connection with bomb making.
Okay, so they want to question him now. If I can just ask you, are you saying that questioning, for the Spanish authority, questioning is sufficient to meet the test? Because we have to balance the rights. He's got a right to stay here. You say, well, you can interfere with that. Are you saying that the Spanish authorities wanting to question him is sufficient? And if so, why?
Yes, I would say it's sufficient because it is within the public interest to ensure that we uphold international obligations to prevent crime.
Thank you. Tracy?
In the approach of the court in this case, I shall reflect the approach from Norris onto this case. In this case, the interference of the appellant's Article 8 right is proportionate because the extradition does fulfil a pressing social need and fulfills a legitimate aim between Type 1 countries to honour and continue international cooperation in the fight against crime. Thus, all member states trust that each other shall uphold and honour any agreement they are signatory to. May I refer your leadership to tab I of the bundle, which references the speech of Lord Phillips.
Yes, I have that.
He states, "It is of critical importance in the prevention and disorder of crime that those reasonably suspected of crime are prosecuted and, if found guilty, duly sentenced. Extradition is part of the process of ensuring that this occurs on the basis of international reciprocity."
Now, can I stop you there? What Lord Philip describes as reasonably suspected of a crime. Now, putting it to the facts of this case, do we have sufficient to suggest that he is reasonably suspected of a crime?
Yes, we do.
Okay. And can you tell me what that is? What the
He
basis
was
of that
found
is?
He was found with packages of fertiliser, flour and packets of nails, and furthermore, the Court of Madrid issued a warrant and wished to interview him in connection with explosives and bomb-making materials found in Madrid.
I'm obliged.
Therefore, showing the value the court's place on ensuring international mutuality in preventing crime between states. This legitimate aim should be pursued on the basis that he is suspected of crimes in Madrid, and as such, in the pursuit of ensuring the prevention of crime, he should be extradited. May I now refer your leadership to tab J of the bundle, which refers to Lord Hope's speech.
Yes, I have that before me.
The court placed heavy weight on ensuring the public interest is accounted for, and as such, there is a very high threshold to surpass for an appellant to be successful in proving their Article 8 rights would be infringed. He states, "The reality is that it is only if some exceptionally compelling feature or combination of features is present that the interference with the Article 8 right that results from the extradition will fail to meet the test of proportionality. The public interest in giving effect to a request for extradition is a constant factor, and it will always be a powerful consideration to which great weight must be attached. Therefore, for the appellant to avoid extradition, it must be proven there are exceptionally compelling features which distinguish his case from all other normal extradition cases. I would submit that the facts of the appellant's case do not give rise to any exceptional circumstances which would render his extradition disproportionate. In the case of Norris, although the appellant suffered from crippling ill health, old age, as well as being in a relationship of dependency with his depressed wife, the courts held that these circumstances were those normally associated with extradition, and thus his appeal was refused.
And are you suggesting similarly in this case that there isn't anything which would meet the high standard?
I shall just go on to that now, my lady. In the appellant's case, from the facts, all that can be deduced is that he will leave behind a wife and children. Of course, his extradition would cause distress, but following Norris, it is unlikely to be held as so exceptional because it is a normal consequence of extradition. Thus, the pressing social need must be followed, and as such, he should be extradited. I would therefore urge your leadership to follow this case on the facts and not those cited by my learned friends. I would submit, therefore, the pressing social needs outweighs the state's interference with his Article 8 rights, and as such, the extradition is not premature. If your ladyship has no questions, may I move on to my second submission?
Yes, please.
Both Spain and the UK are party to the European Convention on Human Rights. As such, the principle of mutual trust operates between the countries in which they can rely on each domestic state's court to uphold the articles of the Convention. Thus, all member states trust that each other shall uphold and honour any agreement they are signatory to. Mutual recognition, established by my junior, is the way in which this trust is demonstrated. May I refer your ladyship to divider 1 of the bundle, which references the case of Hilali, already cited by my junior counsel. Paragraph 77 on tab L of the judgment states,
Yes, thank you.
it seems to us that the court should give great weight to the fact that Spain is a Western democracy subject to the rule of law, a signatory to the European Convention on Human Rights and a party to the framework decision. It is a country which has and which applies the same human rights standards and is subject to the same international obligations as the United Kingdom. These surely are highly relevant matters which strongly militate against refusing extradition on the grounds of the risk of violating those standards and obligations.
Now, that is absolutely correct, no doubt, but can I have your submissions, if you have any, that you can give us in relation to the Commissioner and his comments in relation to Spain's history of problems with the area of human rights that you've heard from the other side?
The Commissioner's report as regards to what, sorry, my lady?
We heard from the other side that there was a view taken that Spain has a history, a significant history, of problems with ensuring that the human rights are properly dealt with, particularly when it comes in their country to keeping people in custody incommunicado. And there was a report on that, you'll have heard. Can you give me what your argument is in respect of that?
I would submit that because Spain is a signatory to the framework of the 2002, that these circumstances cited by my opposition are exceptions, not the rule. Of Spain, in the case cited by my opposition, in this case it did breach their international obligation. However, that is not the default position to be taken when we approach problems like this. To reiterate,
what you're suggesting is that we have to look at the particulars of this case and not look at the particulars of the other case.
Indeed, it should be judged on a case-by-case basis.
And the other case you're saying is a matter which relates to the a general position, whereas we have to take it, in the paragraph that you've highlighted, read out, we have to take it that there are already procedural safeguards in place. Indeed. For the other member state. Is that
Indeed.
your position?
I would also just quickly like to draw your ladyship's attention to Article 19 of the framework decision. Although it has not been highlighted, subsection 1 also further provides provisions for the accused.
So where is that? I can find that, please.
Article 19 of the framework, although not highlighted, it's under divider 3.
Divider 3, it's not highlighted, but it's 19.
Yes, section 1 provides other provisions for the accused on arrival.
Okay, thank you.
Therefore, the appellant's complaint of the prospect of Spain breaching his human rights under Article 3 is misplaced. As in the judgment, Spain is a signatory of the Convention and applies the same standard as the UK, and therefore the risk conveyed by the appellant is futile without actual proof. To further this point, may I now refer your ladyship to divider 4 of the bundle, which refers to the 2010 case of Kotwa against Poland. This can be found on page 1000 of the England and Wales High Court reports. Here, on tab M.
Thank you, yes.
The judgment states, paragraph 4, In my judgment, the starting point in the absence of competent evidence to the contrary must be that Poland is a country which has been a member of the European Union since May 2004 and is a state party to the European Convention on Human Rights. But most importantly, it has been designated a Category 1 territory for the purposes of the Act. I am satisfied the clear inference must be that Poland and those concerned in Poland with the prison system will act in good faith and respect the appellant's human rights. Moreover, as provided for by paragraph 3 above, the evidential burden is on the appellant in this case to prove a potential breach of Article 3 upon extradition. In this case, the appellants have not done so because it is an exception, not the rule. As such, there is an assumption of trust that all signatories shall act in accordance with the European Convention on Human Rights, and most importantly, shall respect the rights of the parties within their country. To project this analysis onto the present case, Spain are a signatory to the European Convention of Human Rights, and therefore the default position is that they shall respect the rights of the appellant. Spain crystallised this obligation upon ratification of the European Convention on Human Rights. Therefore, without proof, the appellant's allegations hold little bearing over the court. I realise I'm out of time. May I conclude?
Yes, please do.
The circumstances of the appellant's case do not contain any circumstances which make the extradition disproportionate or premature. Therefore, his rights under Article 8 have not been infringed, as they are upholding the high value placed on the public interest, as demonstrated through the case of Norris. Further, I would submit to the court that there is no sufficient evidence that the appellant shall be tortured, subject to torture or inhuman or degrading treatment or punishment. Spain is a party to the European Convention on Human Rights and is therefore bound by it when it joined in 1986. Therefore, this is a clear inference that Spain, being a signatory to the Convention, will act in good faith and respect the appellant's rights in respect to Article 3. It is for these reasons, coupled with my junior submission, that I would ask the court to dismiss the appeal and extradite the appellant. If I can be of no further assistance to the court, that will conclude my submission.
I'm obliged.
Sorry, I didn't